Good afternoon, everyone. This side Priya Khanna, and I'm going to talk about a very controversial clause in criminal laws, which is sedition. Before I start, I would like to say thank you to Sanjay sir for giving this opportunity to present my views on sedition. Now look at the text of section 124A IPC. Whoever by words, either spoken or written, or by sign or by visible representation, brings or attempt to bring into hatred or contempt or excites or attempt to excite disaffection towards the government is punishable under this section. This is a very important area of law because its use and misuse has lasted more than century and a half. Now, this section is cognizable since 1978, non-bailable, non-compoundable, triable by session code, and the imprisonment can vary between 3 years, life and 3 years. It is a part of chapter 6, offences against the state. So not only the commission of this offence is punishable, even attempt to do so is also punishable. If I may go to the historical perspective, we have case like Socrates. Socrates become best known as for his questionnaire of everything and everyone. Therefore, he was questioned to violating as prevalent moral standard and he was sentenced to death. Another example, we have the trial of John Peter Zenger. If I go, basically the historically the sedition being used by government, especially to suppress the dissent by the colonial government basically. And in India we have cases like Bal Gangadhar Tilak, Mahatma Gandhi, Arundhati Roy, Vinayak Sen, and now the recent example of the Kanhaiya Kumar. It is also noted that it was added as an amendment to the Act in 1870. Even after the 1947, after independence, there was lot of criticism of the sedition since it was seen as a colonial government imposed on the native Indians, and while addressing First Amendment 1951, the Prime Minister remarked that, I am quoting, now so far I am concerned that particular section 124A IPC is highly objectionable and obnoxious. It should have no place for practical as well as for historical reason. So this was lot of criticism even after independence. Now let's talk about the pre-independence development of section 124A. So there was the first case, Queen Empress versus Jogendra Chandra Bose, where the disaffection towards the government was defined. Another interpretation of section 124 was given first time in Queen Empress versus Bal Gangadhar Tilak. And then after in the Amba Prasad case, which is also an important case where the Court of Session of Muradabad found Amba Prasad guilty of the offence which he had pleaded guilty under section 124A of the IPC. Then we have the another important case, which is the Sadashiv Narayan Ballarao. In this case, the Privy Council effectively ourselves overruled the Federal Court of the Indian decision, and in Nirarendu Majumdar, where says that we have to look section 124 in the wider possible way, and the excitement of feeling of enmity to the government is sufficient to make one guilty under section 124 of the IPC. So this is the development of law in pre-independence. Now move to the post-independence. In the post-independence, we have the important cases like Ramesh Thapar case, Ram Nandan case, Tara Singh case, and Balwant Singh case. In the Ramesh Thapar case, where the court held incorporates the right to the freedom of publication. Now we have, but in the Ram Nandan case of state of Uttar Pradesh, 1959, where it was declared that section 124A as ultra vires to constitution. But further, it was overruled in the Kedarnath Singh case, which is a landmark case, which I will discuss after 2-3 cases. Now in the Tara Singh case. In Tara Singh case, section 24A of the Punjab Safety Act was challenged, and the petitioner challenged and say that this section is no longer valid because now we have freedom of speech and expression, and the High Court declared this section ultra vires to Constitution of India. Now we have the another landmark case where the Constitution bench now goes back and interpreted it and said in the Kedarnath Singh case that there has to be nexus with violence being caused. You can't just have words spoken that cannot be the basis of sedition. So there has to be violence being caused. The person can only be charged with sedition if there is incitement to his violence and his writing, in his violence, in his speech and writing. So this is the turning point of the section 124A, where the Supreme Court upholds the sedition in its modified form. Now we have the another important case, which is a balanced judgment, the Menka Gandhi judgment. The balanced judgment, it is one of the best judgment where the Supreme Court stated that criticizing and drawing a general opinion against the government policies and the decision with a reasonable limit that does not incite people to rebel is inconsistent with the freedom of speech and expression. Now we have the Balwant Singh case, which is also very important case where the Supreme Court held that mere shouting of slogan without anything further is not a sedition. Now we have another landmark and the recent case of the 2015 where the section 66A was struck down, infringes the fundamental speech right to freedom of speech and expression. So this is the development of pre-independence and the post-independence and the interpretation of the sedition section 124A. So this is all we have. Thank you.